Encumbrance. Encumbrance is the type of interest in real estate that does not rise to the level of ownership or possession, yet still gives the individual business or entity some degree of use or control of the property. Yes, it could be possible that a person does not have ownership of the property. They don't possess the property, but they do have some degree of control. And then some of the things that we'll look at here briefly is liens, deed restriction, easement, things of that nature that gives individual business or entities some degree of control over property that they don't have ownership of or possession. It's called encumbrance. Okay, we're going to look at easement. There are four types of easement. A easement is the right to cross or otherwise use someone else's land or property for a specific purpose. Okay, let's look at easement appertaining. Easement appertaining has two separate parties. One is called the servient estate or the servient tenement. The other one is called the dominant estate or the dominant tenement. In order for an easement appertaining to exist, this must be two adjacent properties owned by two separate parties. Here, we'll see Elm Street is a public roadway, and the dominant estate don't have any other means of accessing this property besides crossing the servient estate property. This is called a easement by appertaining. A easement engrossed is an individual or company rights or interest in using someone else's land. For an example here, we see that the utility company has a easement here to run the power lines. It's not limited to utility company. You may also have a railroad company that actually run the railroad through individual property. That would be a easement engrossed. A easement by necessity is when an owner sells a parcel of land that has no legal access to the street or public way except over the seller's remaining land. An easement by necessity look a lot like an easement and appertaining. However, easement by necessity would be ordered by a court. Whenever a property owner don't have access to their land, the property cannot be deadlocked. You must have access to the public highway. So under those circumstances, when there is no access except to cross over someone else's property, the court will order a easement by necessity. A easement by prescription is when an individual, without the owner's permission, has used someone else's property for a statutory period of time. That usually run anywhere from 10 to 21 years. But the use must be visible, it must be open, it must be notorious, and the owner must have known or should have known about the use of the property. Under those circumstances, easement by prescription may be granted. A easement can be created one out of three ways. The first one is through a written agreement. An easement and appertaining and easement and growth are created through a written agreement between two parties. The other two ways is easement by necessity and easement by prescription. Easement by necessity and easement by prescription doesn't need to be an agreement between two parties. It can be issued by a court order. Terminating the easement. When the need for it no longer exists, when the dominant or the servant tenement becomes the owner of both properties, when the easement holder releases the easement, the abandonment of the easement, and the non-use of a prescriptive easement. Okay, let's look at license. When you have a license to use someone else's property, a license is a privilege. It's not necessarily a right. It's different from a easement. A license is when somebody orally informally give you permission to use their property. You don't have a right. You have a privilege at that point, and that privilege can actually be terminated by the person who given the license or the owner of the property. All right, encroachments. An encroachment is when a building, fence, or driveway illegally extend beyond the boundaries of the land of its owner. For an example, if you build a fence on some outside of your property boundaries, right outside, it could be 1 feet outside of your property boundaries. That's an encroachment. You have encroached on to someone else's property. Even if a tree limb that's on your property extends over to someone else's property, that would be called an encroachment. You are encroaching onto someone else's property. Okay, lis pending. It is a Latin term for litigation is pending. It's a notice filed in the public record of a pending legal action affecting the title to or possession of property. Although there's probably no disposition in the case because the litigation is still pending. However, it creates a cloud over the title, and the cloud is a concern about what might happen in this pending lawsuit. So remember that term. Okay, let's look at liens. A lien is a charge against the property that provides security for a debt or an obligation of the property owner. A lien could potentially affect or will affect the sale of the property. Here at the bottom of the screen, here we have some examples or some types of liens. This is not a all-conclusive list. Real estate taxes, your annual property taxes, if you haven't paid it, that could place a lien on the property. A mortgage, of course, would place a lien on the property. A judgment filed against you that probably has nothing to do with your property. If a judgment is issued by court, that person could potentially place a lien against your property. A mechanical lien, if you had renovation done to your property and you haven't paid the contractor, he can place a lien against the property. IRS taxes, utility bills, things of that nature could potentially create a lien against the property, and these liens have to be paid at the closing of the sale of the property. Okay, deed restriction. A deed restriction is a restriction placed in the deed that limits the current and the future use of the property. A deed restriction cannot violate any law. It can't discriminate against a minority group, things of that nature. An example of a deed restriction would be there was a gas station at a corner on a main street and it was a commercial building for sale right across the street. The gas station bought the building, then turn around and put the building back on the market for sale. But prior to putting it back on the market for sale, they put in the deed restriction that the building cannot be used for a gas station because they didn't want another gas station to buy the building and be right next to them as competition. That's an example of a deed restriction. Covenant conditions and restriction, often referred to as CC&R, is often used by subdivision developers. They would place certain covenant conditions and restrictions in the deed to the property that may limit the use of the alterations of the property.